Trial Lawyers University, where the Titans come to train. Produced and powered by LawPods.
All right, we got Joe Freed back with us today, and Joe has got a big schedule of 2 trials coming up for TLU Vegas. So these are busy times for Joe. What are the 2 trials you got coming up?
We got 2. Yeah, it's 2. August 12th, of trying a case against that's an Amazon local delivery case, and then the very following week, the next Monday, I start a case with Joe Camerlengo down in Florida. That's a serious brain injury trucking case. So a lot going on. They're both cases I got into pretty late, so I'm getting ready and also learning them for the first time. So a lot going on.
But one of the things in Vegas that you're going to be teaching with Joe on is Amazon.
That's right. It's I mean, really, for people who are in trucking, they know this. People who are not will know soon enough that Amazon is kind of the directionally where trucking is going. It's really what people need to understand now, because I call it the Amazonization of the trucking world. As Amazon goes, so is the trucking industry going, and there's a lot of interesting developments in that area that Joe and I are going to break down for everybody at the TLU Vegas program. Should be really good.
I'm sure it will be, because I know you guys are putting a lot of work into it. And but before we get to that, you were I'd say a cop, police officer, put it nicely, prior to becoming a lawyer.
First time you've ever been nice about anything police officer related, but go ahead, Dan.
Right. But how do you think being a cop helped you in your, practice, as what you do as a trial lawyer?
It helped me grow up. I had, for, a 6-year time period while I was doing that, I had to learn how to interact with every kind of human being in just about every kind of situation that you could imagine. And you had to be able to jump from situations that were, sort of regular, normal, day-to-day kind of things to crazy, crazy things that you wouldn't even believe me if I told you some of them. And you had to jump back and forth. And so I started policing when I was very, very young. I was 19 years old, and it helped me grow up, and it was really, really good for me, for lots of reasons.
I can imagine.
Summarizing it is, it made me see that it made me understand the world in a very, very different way, very quickly, than what I had known it to be before that.
All right, and then, being in the courtroom a lot, and testifying a lot, kind of, led you down this path of being indirectly or directly to being a lawyer.
Very directly, actually. I mean, you and I have talked about it before, but, for me, I spent lots of time in courtrooms when I was a police officer. And from the very, very first time, and every single time, all the way until today, when I walk into a courtroom, there's something about the feeling of a courtroom that's different than anywhere else to me. And you get the feeling and the sense that important things happen there. As a police officer, one of the things that I got to see was that justice is far from blind. And it didn't take long for me to realize that who you have as your lawyer is a very big deal. It's almost just as important as what the facts are of the situation. I mean, who you have as a lawyer and the skill of that lawyer and the relationships of that lawyer and how that lawyer operated is the difference sometimes between jail and walking out. It's the difference between big numbers in the civil case and not big numbers in the civil case. And I saw that as a police officer. And then I guess about 4 years into law enforcement, a judge who I was in front of a lot actually sent word through my supervisor that he wanted to see me. I thought I was in trouble. I thought I'd screwed something up. He sat me down and without getting into all the details, essentially he really encouraged me to consider law school. And that was about the same time my dad was really encouraging me to look beyond law enforcement. And so those things kind of came together for me and took me in the direction of law school. So where it all started.
And when you got out of law school, you were a little bit older. So how old were you when you got started?
I wasn't that much older because I was policing all through my undergraduate years, so I didn't really have a regular college experience. I didn't get invited to a lot of the parties, um, So, so I was 27 or 28 years old when I got out of law school, and so and I got out and I went and became a law clerk. I was a federal law clerk for a year, which was a nice bridge the gap kind of a thing between the sort of academia and the real world. Got to see what the sort of inner guts of a federal court system was like under a very strict judge who was known far and wide for being strict. I then got out in the real world and realized the rest of the world's really all not that strict, but he sure as hell was.
Joe, how do you think, because so many people, before they go, start practicing, they do go get clerkships. And so how do you think that federal clerkships helped you in your development as a trial lawyer?
Well, my judge was very active. I think it really depends on the judge because just like you go around the country, and you see trial judges who don't try cases. I mean, it's the most amazing thing. I mean, they're like their cases don't get tried and cases don't seem to keep moving. I think it would be boring as sin to be a law clerk in that kind of an environment. My judge was very active, and he was also he treated his law clerks almost like his children. I mean, he was very open to me in terms of helping me see what his thought processes were. And he, unlike also a lot of judges, he was a real trial lawyer for years and years and years before ascending to the bench. And so he had the great stories about that were instructive. Some of them were funny also, but a lot of them were really designed to teach me, how to do it right. And so he was a big advocate for, being well prepared and doing all those kind of things. I got to see lots of examples during my clerkship of good lawyering, and then lots of examples of bad lawyering, wherein he would use either one as an example to teach me. So he would pull me over and say, "See what he just did there? What are some other options that you could have done in that kind of a situation?" And we would talk through it. So it was a great experience for me. I also got to see, he was a federal district court judge, and he was very conservative in his views, but he took his job so seriously that he left me feeling really good about the legal system, and I feel like it's important to look for opportunities to say that these days because the system is so much under attack from people saying it's broken. And the truth is, there are some parts of it that are probably broken, but there's a lot of really good stuff in our legal system. And so it was a great way to start, bridge the gap between law school, and I also got to see how smart lawyers interacted with each other and with cases and with courts and with the secretary to the judge, and just how this game got played. So it was great. I also really encourage people, if they're in law school, to take advantage of programs that would allow them to get into courtrooms while they're in law school, whether it's through mock situations like mock trials, trial teams, things like that. But also, I practiced under what in Georgia was called the Third Year Practice Act, which you could literally appear as counsel of record in cases as long as there was another lawyer practicing with you. And I worked in a prosecutor's office, and I got my first, I don't know exactly, but it's close to 10 trials before I ever got out of law school. I lost by the way, just as an anecdote, I lost my very first case. So I was never an undefeated lawyer, not even the first one.
Well, you're not alone in that one for sure. I know that for sure. But after you finished your law clerking career, where do you go from there?
So I was a second year law student. I clerked for a defense firm, and I had accepted a job at that defense firm. They were going to hold the job open for me to complete my clerkship. And in February of that year, my oldest daughter, was born, Sophie. And the about that same time, I learned that I was going to be assigned to the railroad hearing loss litigation team, which meant that I was going to spend God knows how many years taking a notebook off of the shelf and questioning people who had had hearing loss who worked in the railroad, and that was going to be my life, which did not thrill me. About that time, the secretary who worked with me when I was a law clerk called me to congratulate me for my daughter. We talked, and she told me that she was working for this small plaintiff's firm that did medical malpractice cases. And while medical malpractice wasn't necessarily my thing, I said to her, keep me in mind because that's the kind of practice I ultimately would love to be in once I get my feet wet. The very next week, she called me and she said, "Hey, I mentioned this to the partners. They 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 made one guy a partner, the other guy got pissed and left, and da 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 da. So they want to see you." And I was like, "Well, I've already signed a signing thing to go work for this other firm." She said, "No, I made an airplane reservation for you to come, and they're looking forward to it." So I talked to the judge, and he looked into that firm and those lawyers, and he said, if you really want to if you're interested in the plaintiff side, they're extremely well respected. And so I went up, and literally as soon as I sat down with those guys, I knew I was home. Uh, so I backed out of the other job, and I went to be a plaintiff's lawyer. I took a pay cut to do it. It was a scary time. I was relatively new in marriage, and I had a brand new baby and a lot of law school debt, my own and my wife's. And so I moved back to Atlanta to embark on this thing called the practice of law, which it was a scary time when I think back on it, frankly.
Were you a federal law clerk? It wasn't in Atlanta? It was some.
I was in Savannah, Georgia, which is about 3 hours, 3.5 hours from Atlanta on the coast, right above Florida.
Yeah, that's a really beautiful town, by the way.
It is.
Just
It's a
there
beautiful
last
town.
summer. Spectacular place. Big fan of Savannah. But so you get this job at a plaintiff's firm, and you spend how many years there?
I started there in 1994, and I was there until 2006. So 12 years, 11, 12 years. Um, I started out um, doing medical malpractice cases, mostly birth trauma cases. Um, and then after a few years, I stopped. I did less and less medical cases, and at first I was doing roadway defect cases, and then I happened into a case against Ford Motor Company that involved a post-collision fire, and that took over my world. So that was right about 2000. So the last 5 years of my work at that firm, I was the auto products guy in a med mal firm, which, you know, didn't make any sense at all from a business perspective, but that was my home. That's where I had amazing mentors there, phenomenal lawyers, and I didn't really want to leave.
But your mentors, what did you learn from them that's helped you, to kind of develop your own way and, your trial game?
Um, well, I had two mentors, both in the same firm. They were the two main named partners, if you will, at the firm. Ben Williams, who's no longer on this earth, and Phil Henry, who still is. And I first came up under Ben. He was a scrapper. I mean, he was a trial lawyer. He was a in-your-face guy, amazing on his feet. Knew medicine better than anybody had ever known. In fact, defendants and defense experts would call him Dr. Williams. I mean, he was amazing with medicine. What he taught me was he taught me both by positive example and negative example about that to do what we do requires a really in-depth level of attention to detail. And so he was a guy who, I don't know, he never slept, man. I mean, he'd call me at 3 o'clock in the morning and he'd say, "Get your ass over here, man. I think I just figured this case out." And he expected me to get my ass over there and sit down. And he looked like he hadn't slept, a wink and chain smoking. And, it was crazy. But we tried some cases together. I learned a tremendous amount from him. I also, from him, I learned other things too. I learned that being tough didn't mean that being prepared was the most important part of this to a significant degree. That kindness was something you could still do. I mean, he was one of the most generous people I ever knew. I'll tell you a real quick story about him. When I took the job, I had said no. I told you I turned down the other job that I had, and I had already gotten paid like $10,000 from this firm as a signing bonus. And of course, I didn't have $10,000 to pay, and I was going back and forth corresponding with the senior partner at this other firm. Them basically saying, "You need to return the $10,000." And at the time I had a baby, I had a wife. I mean, I had no money. I had debt out the wazoo. And one day I came in and I just saw on my chair a note that was addressed to the senior partner of the other firm from Ben, just saying, I didn't know things were that hard up over at your place, that $10,000 was going to make that big of a difference, but enclosed is my personal check, for $10,000, which was $1 million to me at the time. Then later when I went to buy a house, I was short money buying a house. Ben just gave me the money and said, pay me back someday if you can. He was just an amazingly generous guy. So I learned a lot of life things from him. I learned one of the important things for lawyers that I learned is, I remember him teaching me that if you're going to be in this world, as a plaintiff's lawyer, you better fall in love with the idea of paying out lots of money to referring lawyers. Don't look at it as, don't cringe when you have to write that check. Love it. I mean, just you gotta really enjoy that process. And so he changed my mindset about that. Phil Henry taught me that he was very different. He's a consummate gentleman lawyer. He's about like 6'5", 6'6", and the opposite of me. I'm short, and to me, he's like Mr. Gentleman. And I learned from him the importance of long-term thinking. Like, be a long-term player in this game, not a short-term player. So make decisions based on your long-term reputation, not based on your short-term reputation. I give you lots of examples, but I don't want to go on forever.
All right. Well, it's good moving from the, because it's so hard to get mentors these days. That's why I asked you about it. And because people are so busy and, people move around so much.
Fortunate.
Pardon me?
I'm so fortunate that I had them in my life.
Yeah. And that's kind of what, I aim to do with Trial Lawyers University is to, provide that opportunity both for the, the people that need help, but also for all the people that want to help. If you want to help and you have lots of skills and knowledge, it's helpful to, have a place that you can do that at, right? Because
absolutely true. And I gain a lot. I mentor a number of people now and have for a number of years. And I feel like I get as much out of it as they do. It's great to be a mentor.
Joe, let me ask you, you've been a lawyer now, almost 30 years?
30 years.
30 years. So out of those 30 years, what accomplishment are you, professionally, are you most proud of?
I think I'm most proud of the work that I've done in the trucking arena. In that, I don't think trucking litigation would be what it is today were not for the work that I've done. And it sounds so bragging when I say that. I don't like doing that, but I mean, that's been my life. My life as a lawyer, this part of my life has been about figuring out how to be the best lawyer within that space, and then teaching that and pushing it out in the world. And I know that we've made a difference. We've done it. We did it before ATAA through AAJ's Truck Litigation Group, and really poured into lots of other people. And then, the Academy of Truck Accident Attorneys, which, I co-founded with Michael Leeserman, was designed to kind of peel the politics back from a trial lawyer organization perspective and just be able to focus on one area of law. And that's grown now to 1,500 plus people. And for an area as niche as trucking, that's a big deal. And so I know that we've made a difference there in ways that some of them are quantifiable and many of them aren't. So I'm most proud about that, I think, at this point.
All right. And as you look back upon it, if you could change something or, do something over, what would it be, in your career?
Yeah, it's a great question. I'm not a guy who lives in regrets. I don't think that serves us very well, because it's not about the past as much as what I can do right now. And so what I'm doing now that's different than I've done before is I'm more available to be a father than I ever have been historically. And I think I'm a much better dad now than I was when my kids were younger. And it's to my loss that I wasn't able, that I was so, Dan, I was so worried about trying to develop into being somebody, have some worth in this world as a lawyer, and have some level of success as a lawyer and all those things that I sacrificed on the home front too much. And that's true probably as a husband as well. Not probably, definitely. So I know those are cliche things to say, but I'm not going to go back and say I wish I had done them differently. I think I did the best I could with what I knew. But if I could do it again, knowing what I know now, I would be a more present person in whatever I was focused on at that time. So I was so focused on law and trying to be successful in law that I was not, even when I was with my kids, I wasn't really, if you know what I mean.
I do know what you mean. But let's talk about, you last taught with us in Huntington Beach, and, that was, I was pretty stoked about that program and just how it went and everything. But that was just
got a lot to be proud of there.
Well, thanks. I'm looking for because that one I got really dialed in because it's the same venue 3 years in a row, just improving it and growing a little bit every year. And I got some new stuff planned for next year, Huntington Beach.
Next year, I expect them to change the name of the hotel to the Dan Ambrose Huntington Beach property or something like that, because you took over that hotel this year. And I think by really having it, I mean, for people who weren't there, I mean, literally from the minute you walked in, the venue came up to the place, it was like placarded that this was TLU, like the gang war had started and we were TLU. And you came in the front door and there were ping pong tables set up and people were in a festive mood. And right from that beginning, sort of walking through, there's music. It's a beautiful venue all the way around. And I think taking over it the way you did took a lot of guts for you to do, and it paid off. It was really nice. And then that kind of lobby experience became a place for people to, every day you were there and people played ping pong and people hung out and, danced with the DJ. And, it was fun. It was fun. And then there was all the great programming on top of it. So
yeah, it was. Thanks, man. It was really dialed in. I got a few improvements for next year, but Vegas is always a little bit different program because we changed the venue this year to Caesar's Palace as opposed to Mandalay Bay. So that's overall been well received because it's a beautiful hotel, right? It's classic. It's just been remodeled right in the middle of the strip. And it's a little bit bigger program, so we have a lot more offerings. And the best, I think the best trial lawyers, I'm able to give them bigger blocks of time to share their knowledge. And you are teaching a lot there. I mean, you're probably gonna be out teaching more than anybody else individually. Because we'll talk about the other stuff in a moment. But one of the things you'll be teaching is with Satch Oliver, and you two are getting together to combine, speed trial and depositions are trial. Satch's new book and his philosophy on doing this stuff. So tell us about. I know it's still under construction, but what is it that?
It's work in progress, Dan, because we did last year at not this past Huntington Beach, but the 2 Huntington Beaches ago. Satch and I did our first program together like that, where we brought elements of what he had at the time in his thought process about depositions or trial, and where I was with speed trial and trucking specifically, and we kind of put something together. But really, at that time, it was really more Satch did a section and I did a section, and what we're doing, and it's not done yet. We've literally just scheduled a time where we're going to spend a full day, he and I, together, uninterrupted by anything else, to mesh that together so that what we can present is not a section by Satch and a section by me, but a section by us that really is a distillation of these concepts. And what this, we're going to do it in the context of trucking, but it's really going to be great for anybody who does personal injury law, because what we're teaching is a process that you start in the preparatory phases, how to go about looking for and defining what you're going to make your case about. And then when you think about depositions, to think about them in a different way than we have historically. Think about it as creating, instead of just thinking about chapters, thinking about literally a visual set of clips that go together as a chapter. Instead of words on a page on a transcript, think about what this could look like if it was being presented visually, because that's what's going to happen. I mean, anybody who's trying cases these days will tell you more and more and more gets presented just through video. And so what we're used to seeing is a video that has a talking head, and then it goes to picture in picture, and it's either this is big and this is small. It's very, very rudimentary. Compare that to what it could look like, and we're going to show you some things that it could look like. So it's going to be visual. There's going to be sequencing aspects of it as well. How do you take somebody from the beginning and walk them through so that by the end of, especially a corporate representative deposition, in whatever kind of case you're in, by the end of that, you've got something, your trial is largely put together at that point. Instead of just thinking about it as, I just took somebody's deposition, imagine what it would be like if you had all your ducks together before that. And this is influenced by a lot of people. So I'm super stoked by it. And I want to admit, I'm learning in this process, and I think so is Satch. I mean, so we're challenging each other to kind of bring the best game forward, and to and just asking a lot of why questions, and what about this questions, and what about if we change this a little bit this way questions. Why do you do it that way? And so it's I'm really looking forward to that presentation. I think it's going to be a very special presentation. And as far as I know, nothing like that has ever been done before.
And then on top of that, you're going to do 3 hours of speed trial update. Tell us about that.
Yep. And Dan, I haven't told you this yet, but I may invite a couple of other people, if it's okay with you, and I want to talk to you about that. And this is probably the best place to do it on this. But the goal of that section is, I'm going to always, from the rest of my career, I'm going to be talking about speed trial. But what's going to happen for the rest of my career, and it's already been happening for the last number of years, is this is going to continue to evolve. because what's happening now, and it's really humbling to see, is people. I get messages, a lot of them, every week or so. I'm getting messages from people saying, "Hey, I did a speed trial. I can't believe how well it worked." And so I asked them, "What do you mean by doing a speed trial?" They tell me their rendition of what I tried to teach, and it's not me, it's theirs, right? And so what I'm now getting the benefit of is, there's no way I can't try enough cases to develop a whole system by myself that's going to have any real validity. But what I can do is I can listen to other people, and they tell me, hey, this is only my second trial, and this is what I did. This is my 100th trial, and this is what I did, and this worked for me. And I go, damn, that's a great idea. So the idea of this is to constantly being distilling down what I'm learning myself from trying cases and other people doing. And like as an example, in this upcoming trial that Joe Camerling and I are doing, there's 117 doctors who have taken care of the plaintiff in this case over the last 9 years. 117 doctors. Imagine in the traditional sense what that would look like in any kind of a trial that you can imagine. Think about that. Well, you know what we're doing? We're calling a summary witness. We're not calling 117 treating doctors. We're calling 0 treating doctors, not a single one of them. We're using a summary doctor who is essentially the equivalent of a plaintiff's IME. Yeah, he's going to be carefully crafted to allow people to feel what 9 years feels like of care, but not get so bogged down in the weeds that it's imagine how many days and days of testimony most lawyers historically would put up with 117 doctors in a treatment set and trying to make a decision about which ones to call and which ones not to call. I'm planning to present my IME, my summary witness, in less than 1 hour, putting the whole serious traumatic brain injury case medicine up essentially in an hour. And while we as lawyers might scratch our head and say, that's crazy, think about it from a jury perspective. They're sitting there going, shit, I'm going to have to sit and listen to a whole hour about brain stuff? That's a long time for most human beings, right? So now I've said it here, so I'm either going to be a hero or a dumbass at the end of that trial, right? But those are the kind of things like even though I think about this and have for a long, long time, I wouldn't have had the guts to do something like that even several years ago. Using summary witnesses is something that I'm a huge fan of these days, especially as we get more and more, the world turns into a place where it's really, really difficult to interact with medical people before your trial or your deposition. I mean, they're all challenging to deal with. I mean, at least in my world they are, and I don't think I'm alone.
And then the third big chunk that you're going to do is on trucking.
Yeah, there's a lot of trucking that's going on out there. So people who are interested in trucking, you can come out there and hear not only from me, but Michael Cowan's going to do some stuff on trucking too. And so there's going to be a lot for people to absorb about trucking if you're interested in learning about it. What I want to do is I want to go back to the basics, Dan, because I think that it's been a bit since we've gone back to the basics. And for people who have a truck case, they don't want to hand it off to somebody else. They want to do the damn thing themselves. Or they really are interested in learning. I want to take us back to the basics and teach people what I believe the best practices are for the development of one of these kinds of cases from the beginning. And I'll get as far into the process as I can get into it in the time that we have available. So I'm working on that and trying to make it as efficient a speed trial of that, if you will. But as you know from my talks about speed trial, you're not speed prepping for trial. It actually takes you longer to do the preparation so that you can present something that's more focused. But yeah, it's going to be back to the basics. It's going to be roll up the sleeves. Nothing, and I believe that even if you're an experienced truck crash lawyer, going back to basics every now and then is really important. Just like, you know, you go watch world-class athletes, preparing for whatever their event is, whatever their sport is, and you'll see them. You see basketball players shooting free throws. You'll see doing dribbling drills. You'll see soccer players working on ball control. You'll see tennis players doing very basic forehand, backhand drills. So I think that's what keeps us. That's what takes us. That's what it is. That's what it's about. So that's the other piece.
The fundamentals.
Yep.
And
And
then
then I'm teaching with Joe Camerlengo also on the Amazon stuff that we mentioned, I think, earlier. That's going to be a program for anybody who has interest in knowing where directionally trucking is going. They need to really understand what's happening with that. And just so the teaser on that is that there's different kinds of Amazon cases, and unless you know what you're looking for, you won't even know you have one. You might have a case and it just looks like a regular truck case or a regular delivery case, and it doesn't mention Amazon anywhere on the police report, anywhere else. And we go from that to actually holding Amazon responsible, whether it's an 18-wheeler case, a box truck case, or just a local delivery to your house kind of a case. Those are different, and we're going to explain the nuances of each of those kinds of cases so people understand what to look for.
And then you and I are going to do a presentation on stuff that we've been working on as far as, the physical presentation of trial, the story of, connection, the eye contact, facial expressions, or emotional state control, stuff that you've been working on a lot, hand movement, voice, controlling where people look, those kinds of things. And I'm stoked about that because something I've been working on myself. Really it's about connection and how we can get it or how we could practice it. It's not just something, I don't think it's something we're born with. I think it's something that's a skill that's learned.
I think even if you're born with it, you need to continue to develop it, and I agree with you on that front. And, Dan, I know it sounds cliche for me to say this, but I'm coming out to TLU Vegas I want to leave there tired, not because I've been partying all night. I want to leave there tired because I've given everything that I can give. So, and, I want to help make it an amazing program. And, I feel very blessed to be in a posture in my world where I've had these great mentors. I've had a level of success that allows me to now have a platform that I can go and pour into somebody else. And my greatest, thing would be if somebody goes and takes something out of one of these presentations and goes out and has a great experience for themselves on a set of clients. That's awesome. That's victory.
Oh, I'm sure that's going to happen because it just happens, and there's nothing better than getting those phone calls or that email, somebody telling you what they did and how what you shared with them influenced and contributed to what they did.
Every now and then you get they tell you what they did. You go, that's not what I told you. And they go, yeah, but it's worked anyway. I'm like, okay, if it worked for you, that's great. Now I'm going to,
Well, and that's what it's about. I mean, everybody takes what they learn, and, it's like, it can't be everybody. I mean, it's obviously can't be anybody else.
The worst part of Vegas for me is that while I'm teaching, I can't go and see these other absolutely amazing tracks that you have. I mean, I would love to. One of these times you're going to let me come out there and just go and see Sean Claggett do his thing and go and see Brian Panish do his thing. And I'm proud to call those guys friends of mine. And so I know what they're doing, but I'd love to see them teach them on it. And one of these days I'll get an opportunity to do that.
Yeah, when you're retired, but not until then.
Or I'll watch it on TLU
on demand. Well, that's I love because Panish's firm PSR is teaching for 3 days. Claggett, Sykes, their trial college, they're teaching for 3 days. Nick Rowley with his trial by human crew with Jacob Norman.
I think that Nick Rowley guy is going to be a really good lawyer if he keeps
coming along.
Stuff up. I mean, he's on the path. I'm teasing him.
Definitely, but
he's truly amazing. All those people are, and what's crazy about them is you watch them all, you'll see some similarities, and what all of them do in different ways is what you mentioned before. They connect. but they connect from their own individuality, which is what makes them both unique and the same, right? I mean, they're you watch them and they prepare differently, and some of them are 20,000-foot view people, and others are detail people, and there's room for everybody. That's what's exciting to me about now, because I don't think there's ever been a better time to learn how to be the best trial lawyer you could be than now. I mean, and I've got a rising third-year law student daughter who I see what she's getting exposed to now, even through her trial programs that she's doing with school, and being able to see things like TLU stuff and whatever. And it's just, I mean, what a head start. I mean, amazing.
Yeah, and I'm working hard to give more people that head start. So my goal is to give out 100 law student scholarships at this event. I know it's during school, so people are like, well, but I think that, most people could probably get a day out or two off of school to come out if they want to. So, anybody that wants to come, that's a law student, doesn't matter what year, if you're interested in being a plaintiff's lawyer and you want to come to Trial Lawyers University, just shoot me an email explaining, why you want to come and why you want to be a plaintiff's lawyer. And I'm pretty sure I'll be able to make it happen for you. So, because I just think
I'm going to make sure that my daughter knows that, and the people on her trial team. She goes to a small law school in Birmingham, Alabama. I'll give a shout out to Cumberland Law School, but they are although they're a small private school, they're now ranked number 5 in the country with their trial team, and they're competing against all the big, huge things. They do they're very, very actively. Their trial program is really great. And you know who her coach is? Sarah Williams is her coach, who, those of you who don't know Sarah, you should. And if you know her, you know why I'm calling her out. She's a very special human being, great trial lawyer in her own right. She runs basically the Shannara firm. And she's taken a bit of a sabbatical to be a law professor focusing on trial advocacy skills at Cumberland. So pretty special.
Wow. I didn't know she was on a sabbatical to do that. That's a big commitment.
Right. Yeah.
But and my goal, of course, is to, at Trial Lawyers University, is to, have all these tracks, because some people get upset with me. They're like, oh, I remember like Jordan Logan, like Claggett's partners, like, oh, I don't like TLU because there's too many choices and I can't see everything and I got FOMO. I'm like, isn't that way better than having just one choice and people, like half the people on their laptops, not even paying attention? And because that's really annoying. And so, and that's why I record everything too, because so many people are dropping so much brilliance simultaneously. I think it would be a professional sin not to record it, not to make it available, because there's so much to learn. And as you said, like, it's the best time to be a trial lawyer because all the information is out there now. And I mean, but the thing is, if you want it, you have to want it. You have to really pay the price.
It is important, and that I think we're saying the same thing here. It's important for people who are listening to this to know. I know you agree with this. To some degree, it is. I mean, I know it's an overused analogy to use the bicycle analogy. Watch TLU. You're going to watch people about riding a bike, but you got to ride the damn bike yourself. And there are places at TLU, and Dan, you and I mean. You and I are working on creating more of this, where people have the ability to actually go and, not in a sit there on your butt and watch somebody else tell you how to do an opening or do a direct or do a cross, or even how to connect with other human beings, how to look them in the eye, and how to get comfortable with this thing called your body and your hands and your eyes and your movements that you think suck, right? And they might not be great on the front end, but there's ways, so watching is great. And then you have to actually get in the arena, and it can be a practice arena, but there's got to be a systematic way of going through and working on your skill sets, so that because you're never going to try enough cases. You're never going to try enough cases to be constantly, to get enough of your actual maintenance work by trying cases. You're going to have to maintain by doing other things.
And in Vegas, besides the lecture tracks, so we do have like 18 workshop tracks where there'll be a lot of small group training. Nick Riley's trial by Human, he's doing some breakout groups. Claggett's doing some breakout groups. Panish's lawyers are doing breakout groups. I'm doing breakout groups with the, voir dire, cross-examination, and presentation skills that we teach. Ben Rabinowitz is doing a workshop on, expert cross-examination. So there's a lot of these, workshops to do. And actually, we're doing a 4-day boot camp, the October 12th through 15th, for people that want to do like a longer. So it's my version of a trial college, right? Because you got 4 days of that, like we did in Huntington Beach, and then you got 4 days of the conference. But the first day is mostly October 16th. There's a golf outing. Nick Riley's taking a bunch of people out to Red Rock Canyon and do some hiking and some yoga. And then Kurt Zander's gonna take a group of people out to the desert to drive some dune buggies and stuff. So,
and then he's going to dunk them into a cold ice bucket when he gets back, because he's into ice bucket stuff.
He is, but there's definitely
I
think there's gonna be an ice bucket somewhere around TLU. I'm just not quite sure. So
I'm sure you'll have one somewhere.
So Joe,
right.
Let's talk about trial now, because you got 2 trials coming up, but one's a brain injury case, and one's with the 9 years of treatment, and the other one is an Amazon.
The other one is a case where a Amazon delivery van runs over a young child, and he gets significantly injured.
All right,
it's not a brain injury though; he gets a serious leg injury.
And so, when you're getting ready for trial, kind of give us some of the ideas on some of the processes that you go through, maybe like 60 or 90 days out to get ready for that trial.
Yeah, well, let me preface this by saying that a lot of my cases these days, I'm being brought into sometimes 90 days out, and so there are different processes for me, depending upon whether it's a case that I developed from scratch or that I've worked on for a long period of time versus cases that I'm parachuting into, which more and more of my trials are that. I started doing that, by the way, because otherwise I'd never get a trial. I mean, the cases generally that I work up from the beginning, frankly, they don't end up trying. Very, very low percentage of them do. I don't know if that's a testament to doing a good job in the prep, or I don't know what it is, but I think that we can talk about, certainly there's processes that need to happen, and some of them are logistical and some of them are practical processes. And I'm very blessed that I have experienced people in my life in the paraprofessional world and in the professional world. I have lawyers and support staff that thankfully know what they're doing. But there's pitfalls in trial work that if you don't do it, you're going to find yourself in a world of hurt. I mean, the basics are things like making sure that you've got your jury charges done, that you've got your exhibits set up in a way, that you've exchanged your exhibits in a way that the court requires, depending on where you are around the country, that you understand what the court's rules are with respect to trial practice, because more and more, both on the state court level and certainly on the federal level, while the federal rules or the state-specific rules apply, courts have their own rules, their own practices, their own standing orders in some cases, that if you run afoul of, it can be fatal. I mean, the truth, or at the very least, you're making life a lot harder for yourself if you start off having pissed off the judge because you didn't follow one of their basic rules. So to me, some of the things that I think about are, if I don't know the venue really, really well, and that includes the judge, the courtroom, those kind of things, you have to do a visit. You have to find out from people who have actually tried cases to that judge, more than one, by the way. It's better to get the information from more than one, because you'll get one person who has one experience and you'll get somebody else who has a totally different experience. So check with a few people, find out what what the judge isn't telling you, what the clerk's not telling you. What time do they start in the morning? What time do they end in the afternoon? Practical things. Do they take a morning break? Do they take an afternoon break? How long do they break for lunch? What time? Is it set? Is it not set? How do they like to handle exhibits on the front end? In my experience, walking in with a set of notebooks for the court, a set of notebooks for the witness, a set of notebooks for the defense with all your exhibits in them, pre-marked. Now, you're not going to put the ones that are for impeachment, right? You're going to hold some things back that you're going to use only for impeachment purposes, but everything else gets pre-marked so that you're not wasting anybody's time. And then another thing that I think people make a big mistake about is they forget that if you're going to use any video testimony during the trial, I was at a court a week or so ago. I poked my head into a trial, and I started watching this. They put a video on. I started watching it just for a few minutes, and it was obvious to me in the first 2 minutes of watching the video, nobody edited the video at all. It was in the format that it was taken. Exactly. Now, that may be because they were not permitted to do it. Some courts, under some set of circumstances, I could imagine a court throwing their hands up and saying, look, if you guys can't agree, just play the whole damn video. But I got up and left. Thankfully, I could. If I were a juror, I would have been sitting there trying to absorb a 4-hour freaking deposition. So depositions need to be edited. They can be edited. They can be edited and reorganized. They can be all kinds of things. You're going to have to present that to the other side. They're going to raise their objections. You're going to have to make arguments to the court saying, this is my case. I should be able to put up my evidence the way how I feel like it's most appropriate to do. If anybody has questions about how we go about doing that, I'm happy to talk in more length about that. But it's super important. It's a place that I think we screw up a lot. So I know I'm running all over the place. Those are the logistical things. Then on top of that, there's the preparation of yourself for a trial, right? I mean, we tend to work really, really hard getting up to a trial. And so what happens when we, the human animal, works really, really hard to get to a trial? Well, we tend not to eat as well as we should. We tend not to sleep as well as we should. We tend to put all these things off that we'll do them after the trial. We do all those kind of things. You have to be careful. And hopefully you have people in your life who can remind you that, you know what? You work hard, you get ready, but you got to sleep. You got to eat. You got to exercise. You got to take care of yourself. And my recommendation is that you set yourself something that you have whatever you do in your normal life, and you try to continue to do that through the last part of that hard push, that 60 to 90 day time period beforehand. And that includes, by the way, the real last push, which is the last 10 days before. You got to keep that up. You got to remember that that's just as important as the prep. You taking 45 minutes to go ride a bike, swim in a pool, take a walk, do something, whatever your normal practice is going to keep you in the right frame of mind in doing things. And then for me, I tend to think working backwards. So I think from the closing all the way back to the opening. And you can't write your whole closing beforehand, but you can write a lot of it. You want to know, you want to start with the end in mind. So where do you think this thing is going to end up? Right? So you have that already sort of started, largely set up, and you work back through your evidence, work back through your examinations all the way to your opening, and along the way, your jury charges. Motions in limine are a huge, big thing that I think if people aren't used to being trial lawyers, they sometimes it's like, oh shit, am I supposed to do motions in limine? Yes, motion in limines are huge. And, so I think when I'm throwing all these things out here, but I think the biggest things that I would tell you are that you're going into, especially depending on how long your trial is going to be, and I'm a big advocate for shorter trials, but that means a lot of preparation. And even through that process, I I try to maintain my exercise. I try to maintain my eating, try to maintain my sleeping. And I'm not saying it's easy to do. You have to kind of force yourself to do it. What are some things that I've missed, Dan?
Well, Joe, let me ask you though, this on the brain injury case though that you're going to try with Joe C. Tell us, the voir dire. When you approach voir dire in a case like this with a brain injury, you know, what is first of all, what's your mindset process? But then how do you, talk about certain topics like money, sympathy, burden of proof, and obviously traumatic brain injury, and maybe the fact that it's been 9 years since the incident. I don't know if you talk about those things too, but how do you go
Yeah.
about framing those topics in voir dire?
Well, yeah, in that particular one, Joe Camerlengo's doing it, but that doesn't mean that I'm not actively involved with him in strategically going through it because as you and I have talked about many times, and anybody who's spent any time in trial or thinking about trial, you know how important jury selection is. And philosophically, my views on jury selection are different than lots of other people's. To me, jury selection is very much about the connection. I'm not as big an advocate for a lot of what I call the tort reform questions that most people do ask. I'm not saying I'll never ask them, but I just don't think that, I don't think if somebody tells me that, they don't like, that they think there are too many lawsuits, that means that they're not going to be a good juror for me. Or if I deem somebody as being conservative, I get more money from conservative people than from liberal people in my experience. So the process though is one that starts at the very beginning of the case. And frankly, it started before the case ever came in this sense. I constantly thinking about, and you are too, about jury selection, right? I mean, everything, life is kind of jury selection. I practice being interested in what people think about things. I practice listening to people about what they're saying and what they're really saying. You know what I mean by that? Like what's behind what they're saying on the surface level. I practice not coming across judgmental. I am judgmental. Everybody is to some degree, but I practice trying to listen through those things constantly. But then as I start to get ready, and so since I've been doing this for 30 years, I've spent a lot of time in evolution, thinking about things like money and damages, thinking about things like what the hell are we doing in a trial? What is money justice? Does that even make sense? I know how I feel about things like that already. Part of where I learned to do that is trial lawyers college, and you learned that too, Dan. Is that thinking about we bring ourselves to the table, and that's the point that I'm trying to make. And then in the process, when you think about something like TBI, I'm obviously one of the things I always think about is if I'm going to lose this case, why am I going to lose it? What are people going to believe that make me lose the case liability wise? If I'm not going to get the kind of money that I'm going to get, what is it that people are going to think that is going to keep me from getting the money that I want to get? How do I feel about those things? And then I start to figure out how to talk to other people about those things. And then it becomes very, very case specific and very jurisdiction specific in terms of how I can go about doing that. Because I think, as you know, I've handled cases in over 40 states. Every one of those states has different practices when it comes to jury selection. And within each of those states, every jurisdiction and every court and every judge has their own proclivities in what they'll allow and what they won't. So you have to work within the system to some degree. I've learned to ask for what I want, and I've learned to be okay with them telling me no because I have to be, and I have to work within, you have to ask and you can push to some degree. But so I don't know how helpful what I'm saying is, but I think hopefully it is helpful because you better know what the hell you're getting into. I've walked in. There was one case I can think of. I walked in expecting to do a voir dire the way I wanted to do a voir dire, and in court, in the moment, the judge said, "Oh, hell no, we're not doing anything like that." And it was like it was water thrown in my face to try to figure out, all right, well, how can I do this effectively? I don't want to ever repeat that process again. That was a very uncomfortable process. It ended up working out fine, but it was an uncomfortable process. So know directionally what you're doing. And then for me, philosophically, it's about the connection is more important than the content. And I know that's a lot of people disagree with that, but that's my reality.
But you do have content though. So, I mean, like a TBI case, I know Joe's doing a bit voir direing on that concept of TBI.
On the concept of TBI, on the concept of sometimes, depending on the case, again, sometimes that's really about voir direing on the invisible injury, right? So if it was a mild TBI case, this one isn't. So the reason I'm not as concerned in this case about it is there's really not a huge disagreement about the degree of injury in this case. It's a question about how much.
So what happened in this case?
This was a case. It's a rear end truck wreck case that becomes an admitted liability case, and he has a brain hemorrhage. He's in a coma for a period of time. So there's no question that this is a real, it's a severe traumatic brain injury. He basically comes to weeks after the event, and then he's in the process of he has to learn how to talk again, learn how to walk again, learn how to eat again on his own, not through a peg tube. He has remarkable recovery in a lot of areas, but he's left with a situation where he can't be left alone. He has disinhibition, so he says all kinds of stuff that's really incredibly inappropriate. He makes up stories that didn't happen to talk about. Most of them have to do with his sexual prowess. He's very inappropriate with his family. It's quite remarkable that the family has been able to stay together. And this is not their life only for the last 9 years, but he has a 28-year life expectancy. So what I talk about, so for me, content in this case is about things like what are the things, like if I were talking to people, I'd say things like, so what are the things that are most valuable to you? And so if I were doing this with you, Dan, I mean, what are some of the things that are most valuable to you? Don't say TLU Vegas.
Well, seriously, my health, of course, and the relationships I have with other, my girlfriend and my friends.
And what is it about the relationships that make them valuable?
The fact that, I know these people care about me, that I care about, so it makes me feel like,
Loved.
Yeah, loved and like connected and happy and, part of something.
So I'm curious. I mean, what would it be like for you if, and look, if we kept up this, you would produce for me things like my independence, my ability to make decisions for myself, my family, the work that I do. Well, what is it about the work? It's the way it makes me feel. Okay, well, tell me, so what would it be like for you to wake up one day and just know that you will forever be a burden to everybody who loves you? What would that be like for you?
Well, even obviously be horrible, but even like waking up and having nothing to do all day and not having your what you're passionate about, your career, like just losing that. Forget about, even before being a burden, not being able to be a contributor would be, I think, devastating.
Right. And you see what you're doing. Of course, you're being a lawyer here, but to some degree, it's so uncomfortable to think about waking up and being a burden that you didn't really even want to answer that question. You rather, let's talk about something a little bit, let's take a step back beyond that. And this is my voir dire.
Right.
I mean, literally, I'd say. So, I mean, when you did that, you're just like me. When I started thinking about the answer to that question, I didn't even really want to answer it because I don't ever want to think that way. I'm not sure there's anything that much worse. What do you think?
Well, it's
So this is what
inconceivable.
you and I, what
Right.
I'm doing, and I'm talking to people about what are the things most important to you? What are the things, important's the wrong word. What are the things that are most valuable to you in your life? Because you're going to produce these things for me in as a juror. We're going to agree. We're going to have, by the end of our jury selection, we're going to agree on a list of things that are most valuable in life. And they're going to, and you already know what they are, Dan. We can predict them. We know that they're independence. We know that they're freedom. We know that they're family. We know that they're and freedom can take different forms. If you're in the South, my guns, right? I mean, if it's, I'm joking, but not joking. For that may be representative of freedom to me. My ability to make choices for myself, my ability to be of value, of use, right? And then what are some of the things that would be most challenging for me? Well, to be a burden, to be a thing. And then what's going to happen is they're going to see that's what this case is all about, right? I mean, that's what the case is about. And so to me, that's where I'm spending my time, especially on a case like this one, which is mostly a damages case. What I don't do, and it's philosophically different than what a lot of people disagree with this, and I'm not saying I'm right. I'm just saying I'm right for me. I've given up I've given up the feeling of the need to teach medical school every time I have an injury. I'm not putting up diagrams of brains with different segments of the brain and talking about I'm just not doing any of that. I don't feel like it's necessary, and I think it's sort of legal masturbation. I mean, it's like you're not getting anywhere. You're legally you're just treading water because somebody told you. I mean, on jury selection, I tell people all the time, look at your jury selection. First of all, admit that your primary preparation for this jury selection was to pull out your last jury selection and change the names. That's the first thing. And every lawyer that I know pretty much does that, right? And number two, if you look at that list, every freaking question and subject matter that you have on there, the question you should be asking yourself is, how do the answers really help you choose the right jury for this case? And if the answer is, I don't know, but I went to a TLU on demand and they asked those questions, and so I'm going to ask those questions too. That's not a good enough answer. All of us should be able to say, how is this helping you either create a connection or choose the jury? And if you can't answer that question, you're wasting your time because you're and everybody else's time asking the question. So that's jury selection. But we do cover things also in the right case. You got to figure out how are you going to talk about the burden of proof, for instance. And sometimes the burden of proof is a little complicated and getting more complicated these days because you have affirmative defenses. So explaining the burden of proof and explaining who has the burden of proof for what part of a case can be complex, and it's worth talking about in jury selection. I think that's true to a certain degree, but again, a lot of it is. I'm just not a big believer, Dan, philosophically, in the idea that just because somebody says, I might have a hard time awarding $25 million, that they're not going to award 25. I've had lots of people tell me, man, it would have to be an amazing, weird situation for me to award $25 million, and then I get $25 million from them. Right? Just because they say that doesn't mean they're not going to do it. Because they say, it would be hard for me to be the kind of person who would bring a lawsuit. Okay? Even in a situation where I felt like I was wronged or my loved one was wronged, I wouldn't do it. That doesn't mean they're not going to give you a lot of money in the case. I mean, I'm living proof of that. I've got lots of results that belie that. So I just don't. That's not where I spend my time. In most jurisdictions, I'm trading with the judge let me do jury selection the way I want to, which means an open dialogue for time. So I'm saying if you let me do it my way, I'll be done in an hour. Okay. And yes, I said an hour, right? Those of you in California are saying, what, man, I got a week. I'm like, I know, I've been there, but I'll trade, sometimes say, well, you'll have 4 hours, but you're going to use a paddle or people are going to raise their hands, in answer. I'd rather have an hour of a dialogue. So I know we could go on and on jury selection, but I think what's most important is connection. What's most important is to try to understand where people are philosophically without judgment, and then make decisions about which ones are going to be best for you. That should be informed by your pre-trial work, focus group work, your thoughts on what kinds of people would be best for those cases. People are using big data more and more. I'm at the beginning of doing that, so I'm not the right guy to talk about that, although I'm learning and I'm doing it now. But I'm new to it, so I'm fascinated by it.
Are you using it either your two upcoming trials?
No, I'm not using it in either one of these, but I'm getting ready for a trial that will probably, it could go late this year, but it's probably going to go in January. And it's my first one that I'm doing. I'm using
Campbell.
Campbell to do it. We've already done it. We've already done 400 something jurors, got a lot of great information, and we're going to tweak it and do another one.
They're going to be doing a lot, teaching a lot with Claggett, because they just released this book, Jury Ball. But they're also going to teach for like a day and a half just on how they use big data and small data on helping people predict values and put together their cases. So that should be pretty interesting.
Especially with Sean Claggett, we have to be careful not to call him like Big Daddy instead of Big Dada, because somebody might get pissed off about that. Anyway, go ahead.
And file a lawsuit, perhaps.
Probably
crazy people out there from Georgia. In Georgia, crazy people.
Call him Daddy Sean. It's a little different than Papa Sean, but anyway. All right, go ahead.
All right, opening statement. When you're approaching opening statement, like what do you, first of all, do you practice it before you do it? That's my first question. And then what are you trying to really accomplish with your opening and your visual strategy?
Yes, I practice it. And then it never goes really exactly like I practiced it. I mean, if I'm being really honest, because you get up and then you're in action at that point, and it's an interactive process. You're getting things from the jurors and you're giving things to the jurors. But I do practice it. And what's most important to me in the practice is there's certain things I want to make sure I nail. And, one of those is I learned a long time ago that if I nail the very, very beginning, like if I nail the standing up in front of the jurors, connecting and starting, if I nail that, things start to move pretty slowly. So I used to have to do that a lot more than I do now. But I used to, I think I've told you in the past, there was one time I worked with Josh Carton for a number of hours of just getting up from counsel table, getting in front of the jury, looking at them, connecting, and making my first sound, and sit down and do it again, right? So there's a few major points that I want to make sure that I nail, and then for me, what works best is I want to understand my structure. Usually, I'll have 4 or 5 parts of the opening, and if I can just make sure I know the structure. That way, if I ever get lost in the process of the opening, I can come back to where I was in the process. I'm not a big PowerPoint opening guy because that feels too structured to me. I do use visuals in opening, and I do more and more, not every time, I do ask for the money in opening. So that's been a progression. But in the last 5 or 6 years, maybe even 10 years, that's been the direction where I go. So if I'm going to ask for $25 or $30 million in the case, I ask for it in opening. I say this is a $25 million case, and I want you to know that up front so that you can be listening to all the facts with that in mind.
Do Are you more of a specific number or a range kind of person?
Specific number.
Why is that?
Because I think that I think that specific number has more credibility than range. If I'm going to sit there and, especially because most people, the reason they're putting a range is that they're afraid to ask for a real number. I mean, if they're honest with themselves, they're hedging their bets on it. So, and I think for the most part, people only hear from us. They only hear the lowest number in the range. As a general rule, I think that's true. So you might say, oh, yeah, it's somewhere between 25 and $50 million. They just heard 25 million. They don't hear 50. And it makes you feel better to say it that way. But I think, and it'd be interesting. We could do a whole big data thing with Sean about that to see if that's true. But to me, if I look at you, and this is so much true that when I make demands down to the penny. When I say, here is what it's going to take to get this case done, $1,786,444.18. That's the demand. And they go, how the F did you come up with that? I go, that's my demand. That's my number. I could explain it to you, but I don't really think I need to. But that's what it's going to take. Well, they go back, when you have that level of specificity, there's a credibility that comes with the specificity, right? If I tell you 1.7 million, you go, well, I mean, that number, I mean, how likely is it that the right number for a case is exactly 1.7 million? But if I come to you and I've lived credibly, and I am the credible voice in the courtroom, and I say the right number for this case is $1,706,904.18, and that's the right number. I know I'm using that as a teaching point. Now in opening, anyway, look, I think I've answered your question. I mean, we could go on and on about this topic, but I'm a big believer in the anxiety that we as lawyers have about putting a real number out. That's the problem we have to deal with. And the work needs to be done by us, not by the jurors, to get to the number. And so you put it out. Now, here's what I always get is, well, what happens if the course of the trial doesn't go the way you thought? Well, the way I hedge is by saying, if this case goes in the way we expect it to go in, if unless something changes, this is a $25 million case. And folks, if something does change, I'll be the first one to get up here later and tell you it should be a different number. And that way, if something does change, and it happens, it's happened to everybody in trial, right? Something happens. You know what? I thought it was 25. It's only 24.
I was off by a million.
$65,000 from this thing.
Let me ask you, how much you talk about damages and what's happened to your client in the opening?
So I'll give you the lawyer answer is it depends, because some of my trials are only about damages, right? I mean, like a lot of times these days, it seems like there's so many late admissions of fault. So the case is really a damages case. So you gotta do what you gotta do. Now, I think that not only in opening, but throughout the whole case, you should ask yourself, how much do you really want to put in, and who are the best voices to put that in when it comes to damages? So I don't think you need to, like in this case, I just had this discussion with Camerlengo, and is the idea of, okay, we have 9 years of past medicals and we have 28 years of future medicals. Okay. And so the jury needs to understand what I mean by 9 years. I mean, 9 years. I mean, think about it. Where were you 9 years ago, Dan? I'm not asking for the answer specifically, but when you think about what's happened in your life over the last 9 years, a lot has happened, right? 9 years is a long time. I need them to feel that. But just what I just did with you and seeing you nodding your head, there's not really all that much more I need to do other than to say, where were you 9 years ago and what's happened in the last 9 years? And you go, holy shit, that's a long time, right? Now, so we've been thinking about how to do this for a while and thinking about putting up a timeline. so people get an idea of this is the length of time, this is what's going on. But you can quickly lose people. I mean, you want to talk about 9 years, but I can lose them in about 90 seconds, and they've gone to sleep. They're not going to hear anything else about my 9 years. So the challenge in these cases is always, how do I engage with the right amount of information and fight the temptation that all of us lawyers have of over trying our case, right? I mean, like many lawyers, if I talk to them about this case, they would say, man, you got to put up every freaking MRI that was done. You got to put up every time that the doctor said, your life sucks. You got to put, every time there was an EMG, every time there was this, every time da 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 da. You know what? After a while, I mean, how many times does the jury need to know? You know what? I'm not doing any of that. I'm putting up a guy who says, the guy was in a coma. Why was he in a coma? Because his brain was so beat up, he was in a coma. I put up one film that shows bloody brain. That's it. There's no more. There's no. We're not. So you're asking specifically about opening. In opening in that case, assuming it's going to go the way I think, we'll put up, and again, assuming the court will allow us to do it, we'll put up the timeline. And if we can't put up the timeline, then we'll talk about it. What you're going to see in this case, I've got it over here. I just can't show it to you until we get actually into the trial. We'll put up a timeline for you. You're going to see what 9 years is all about. Okay? And I'm going to give you enough information within that 9 years so that you get a flavor for what it was like. But folks, I'm not going to pull on your heartstrings. I'm not going to try to show you everything that happened during that 9 years, because we'd be here for 9 freaking years. But I need you to understand the base. So yeah, I'm planning to talk about the specifics in that opening, but at that level, kind of at the 10,000 foot level, enough to justify the end result, what I'm asking for.
And let's talk about, putting on your case. Who do you think you're going to lead off with in that case, and why?
In that case, I'm leading off with my summary doctor. Remember, it's an admitted liability case. If it wasn't an admitted liability case, I probably wouldn't lead off with the summary. I mean, so the other case, the Amazon case, I'm leading off with the corporate representative for Amazon. Because I'm going right to usually, and look, I'm prefacing my comments here because I think that sequencing is something that should be considered afresh for every case. And there are different reasons to do different things. But I want to get right to the controversy and answer the jurors' questions on the controversy as soon as possible. So a lot of times what I'm doing is I'm putting up the driver or the corporate representative from a company to get up and say, are we fighting about liability in this case? All right. I call it, think of the first witness for me a lot of times is what I'll call a roadmap witness. And it's the defense roadmap witness. I'll put a corporate representative up and say, look, for 5 years, we've been fighting over liability in this case. Yes. Your company does not admit 1% responsibility for what happened. Is that right? That's right. And that's why we have to be here. We need these jurors to decide this for us, don't we? Because we're never coming to terms with each other. Yes? Yes. Okay, so let's see what we agree to and what we disagree on. First question in this case, what are the rules? What are the standards that your driver was supposed to adhere to? Can we see if we agree on those or not? And then we talk about it. I say the rule is this. Do you agree with me? I don't care what the answer is. I'm not fighting with him at this point, right? Just want to know, do you agree? That's the rule or that's not the rule? So you want me to prove that's the rule? Or are you going to accept it? Because I got people, I can prove it if you want me to prove it. No, that's the rule. Okay, so we agree. So I don't have to call anybody. We agree to that. Yes. That's done, right? So I like doing something like that on the front end of a case where I have liability issues. So the question then becomes, so we agree that's the rule. So really the only question in this case on liability is whether that rule was followed or not. Yes. And you weren't there that day, right? And neither was I. So you want me to prove whether that rule was followed or not. And you'll agree with me, if I prove that your driver violated that rule, then you're going to have to revisit your position on responsibility, or you're not going to blame this jury for finding you responsible. Right? And then it becomes, so now right from the start, I want the jury to understand what's the controversy? Where are we? What are we agreeing about? What are we not agreeing about? What is their job in this case? You've heard me say it before. We're always in a trial, we're always employing the jury to do something. It's worth knowing with specificity exactly what it is you're asking that jury to do. What is their job? Very specifically. Every trial lawyer should be able to answer that question precisely before they ever walk into the courtroom. What precisely do I need the jury to do in this case? What precisely do they need to answer in this case? Right? And so right from the beginning, I want to sequence my people so that the jury sees this is the controversy. And for me, I start with liability. I can make the argument, and I can envision situations where I would start with damages, even in a contested liability case. But usually for me, I still think, and maybe this is just old school thinking, that people they want to hear about the liability.
I think most people would agree with you, and laying the foundation for the injuries. That's why the injuries matter, because these people are at fault. So,
and liability drives damages. It's much more so than we give that credit for. I mean, if you really kick somebody's ass on liability, it can carry it can carry your causation for you. It can carry your damages for you a bit, right?
As far as the plaintiff, where do you typically sequence your plaintiffs for their testimony?
Outside the courtroom.
Yeah.
Not in trial.
When they have to come in to testify.
But seriously, the first part is, who is the plaintiff? In a TBI case, the Florida TBI case, that plaintiff is going to be, you know where that plaintiff's going to be? In New Jersey, which is the safest place for that plaintiff to be. They're not going to be a trial at all. In other cases, the plaintiff comes in to be introduced to the jurors, but if they're out of it, and you can have, in the right kind of case, you have a conservator appointed or somebody like that. You've selected who you're having to be the face of the jury, of the plaintiff, right? The conservator is here on behalf of the plaintiff. So I'm putting the conservator up. Who are you? I'm the conservator. Well, why the hell are you here? Well, a court has already determined that this man is so brain injured that he can't take care of his own finances or make decisions for himself. So a court has appointed me to that role. So that's why I'm here. So technically, I'm the plaintiff. Now, with that person, first of all, I've chosen that person. So I should choose that person based on the demographics of the venue that I'm in, right? If I'm going to be I want that person to be very credible. I want them to have a banking background or some kind of a legal background so that the jurors see them as a credible human being. I want to address whatever challenges I have in the case, whether it's race, whether it's, whatever. I mean, I'm putting up a conservator who matches the demographics well, right? And then I can address challenges with that witness, like, let's say you're representing a child, and you've got parents who they're decent parents, but they're not perfect human beings, and maybe their credit sucks, and maybe legitimately even you have allowed yourself to think, if this kid gets a ton of money and the parents are the ones who control that money, the kid's never seeing that money. That money's going to go for all good intentions, but that money's going to go to take care of the parents' debts. Well, I can fix that with a conservator, right? So the other thing that I will say about plaintiffs is, when you're not in that kind of a situation, is I want to expect as little as possible from my plaintiff in terms of telling their damages story. Now, they can tell their life story before damages. They can be before witnesses. If possible, I want people other than the plaintiff to talk about the actual injuries and the challenges. I want one step removed. I want the best friend. Like, even in our brain injury case, so our plaintiff in the brain injury case largely is the wife. I'm going to have the wife's best friend talk about what this has been like for them more than the wife. Because I think that no matter how legitimately damaged you are, when you're talking about your own damages, you sound like you're whining. You sound self-serving. You sound like you're exaggerating, even when you're not. So hopefully that answers some of your questions on that.
It does. And let's talk about cross-examination, though, and your application of speed trial to how you now cross-examine experts in the courtroom and even beforehand in deposition. So, like in this brain injury case coming up, what's some of your, I guess, processes and strategies for handling or undermining your experts?
So first of all, and when you talk about it from a speed trial concept, we jumped over we jumped over directs, but on crosses specifically, the first question I have is what have they hurt me with? I've told them in my concept of a trial, I've told the jurors very specifically what their job is. And here's the controversy in this case. And I've chosen what that is, right? And so now if the defense puts up somebody who goes off on a wild goose chase, and to me, the definition of a wild goose chase is it's not the issue, then sometimes the cross-examination is simply to point that out. Dr. Ambrose, I listened very carefully to your last 3 hours of your testimony. Did you address X in your testimony? Because I didn't hear you address X. No, I did not address X. I was not asked to address X. I didn't think so. No further questions. Now, does that mean I didn't have things I could beat you up with? No, I had all kinds of things I could beat you up with. But what I chose to do is show the jurors that there's not even a need for you to think about this witness. This witness did not touch the case. This is smoke and mirrors, right? So the thing on cross-examination is, it's such a broad topic. Different kinds of experts are going to have to be addressed in different sort of ways. Sometimes you're engaging them on the merits of their testimony. Sometimes you're engaging them strictly on bias, and you don't even get to Dr. Ambrose, is it true that you've testified 192 times? Yes. All 192 of those times would have been for defendants just like this one. Yes, yes. No further questions. How powerful is that? Right? And that's not one of 19 lines of cross-examination where it kind of gets lost in the shuffle. You've said very loudly and powerfully, this is a freaking defense whore. That's all he does. And you don't dilute that with a bunch of other stuff. Well, now let's talk about what you say the brain science is. Why should I even be if you're really a whore, why should I even talk to you about brain science? Right? If I just point you out as the whore and leave you alone. A lot of people, again, would disagree with me, Dan. So I'm not saying I'm right. I'm just saying I'm right for me in the case that I'm envisioning in my head right now. Not easy to do, but like one of the witnesses in this upcoming case is the testimony is on life expectancy is that the life expectancy of this severely traumatically brain injured person is reduced by 7 to 9 years because of the brain injury. Well, think about that. What are they saying? They're putting that up there to try to screw with our life care plan. But wait, you're killing the guy 7 to 9 years earlier, and you want a fucking discount? Think about that. Is that so? What? How do you think that cross-examination is going to go? It's going to be very short and sweet, like just what I said to you right here. Are you asking the ladies and gentlemen to discount? Where do you account for the 7 to 9 years of life? I'm not accounting for that. Okay, so you want a discount for 7 to 9 years because your injury that you caused and you admit to causing killed him. And you want a discount for that. I just want to make sure I'm understanding this right. Fine, no further questions, right? So I think it's short and sweet, and I know that there's lots of challenges to what I'm saying, and you can't always do this. Sometimes you have to engage. And my hope is, I guess the final thing I'll say on the cross-examination is I hope that when I engage, I get my emotional state control right. Because sometimes, we are our own worst nightmare. We come up, we're angry, we're ready to cut somebody's throat, and they appear like a nice person. The jury they don't know that the person's a whore, and they testify in every case, and they've been your nemesis for 82 years. So they come in, you look like this rabid animal, and they don't like you. And they choose the doctor over you. They choose the expert over you. So you got to manage your emotional state in the process. Doesn't mean you can't get upset. Doesn't mean you can't get mad. Doesn't mean you can't yell. But you have to. It needs to be a managed process. It can't be an out of control process.
I think the most, as far as like impeachments goes, or the stuff that may be angry, I really think disappointment is the much more effective emotional state on most of that stuff than anger. When they.
I think that no wiser words have been said in a long time. Think about how you feel when somebody reprimands you in life, whatever reprimand is. I'm using the word broadly. When you know how somebody calls you out, when you feel like you have disappointed somebody else, how does that feel? It feels pretty low.
Exactly. Wait, you said that I didn't ask you about speed trial applied to direct. So how are you going to be apply speed trial to direct in these two cases you got coming up? Other than the summary witness, I got that part.
That's a big piece of it, right? Because
Right.
I've just summarized 117 witnesses, 117 doctors in 9 years, right? But I think that the general concept is that, and again, it sort of depends on the witness, but so like jumping to the life care planner, okay? In that case, I'm putting the life care planner up, and my rule is that within the first 2 minutes, and I like to do it within the first 90 seconds, the jurors know who the witness is, what their role is in the case, and what they're here to talk about. Because I think that that's about the length of time I have to hook the jurors to see if they're going to be interested at all in paying attention, right? So life care planner goes up and say, Dr. Smith, who are you? I'm Dr. Smith. What's your role in this case? I'm the life care planner. What's a life care planner do? Well, I look at all the costs and what's needed for the future. Okay, so there's like 4 areas I want to talk to you about, doctor. First of all, did you create a life care plan to show the ladies and gentlemen of the jury what the needs are for this patient from this point forward? Yes? Yes, I did. Are you the person who costed that out so that they can see what the costs are? Well, I did the basic costs, but I didn't add them all up. Oh, who does that? That's the economist. Okay, so literally in the first, I've not qualified him. I've not gone through his life history yet. Not done any of that. I'm just letting the jurors know, kind of roadmap, what's this guy here to talk about? And then if it was the economist, I would say, I'm going to go through all your opinions, doctor, but what's the final opinion? I mean, did you, to a reasonable degree of certainty, based on all the work that you've done, what's the economic damages, total economic damages for this loss? That's $9.8 million. Okay, so in the first 90 seconds, they know this guy's the economist, and he says the number is $9.8 million. Now we back up, and we go into what makes you the right person to tell us about a life care plan or to create a life care plan. That's my way of qualifying the person. And we do not waste a lot of time on qualification because I don't think jurors give a shit. Now, there are exceptions to that. If you've got a case where it's a battle of 2 experts and your guy went to Harvard and the other guy went to, Guadalajara University, you might want to spend a moment on that. But for the most part, most of the time, people don't care. The doctor from the University of Guadalajara is still a doctor, still licensed. They still practice for 20 years. And they may actually be a better doctor than the other guy, probably a nicer guy, but anyway, that's all another story. So we don't over qualify the witnesses. We ask them very specifically. We get right down to it. This is what you're here to talk about. What makes you the right person to tell us about this? Now tell us as cleanly, as quickly as possible. tell us what the answer is to a reasonable degree of certainty, and we're out of we turn over the witness. So that's the speed trial concept. Is the one other thing is the one other piece before you turn over the witness is what I call insulating your witness, and that's what's the other side. I go ahead and say, what's the other side about to come up here and beat you up about? Literally, that's the question. What are they going to come up and disagree with you on? Well, they disagree with my life care plan. Well, what specifically do they disagree with? Well, they don't think I should. They don't think that Mr. Hentz should get a service dog. That's one of the things in our case. They don't think he should get a service dog. Well, isn't it true that isn't service dog like one of the only things that he loves? Just loves a service dog. Yeah, it's like one of the only pleasures he has in life. Oh, okay. Then you turn over the witness, and they get up and go, "Why do they need a service dog?" So that's the way we do that.
And we're going to learn. All right, and we're going to learn a lot about these two cases, because if they don't settle, you never know. We said one's not selling for sure, so we're going to do a couple one or two case analysis in September. We just don't know the dates because there's a lot of scheduling things, and Joe's very busy before TLU. But we're going to put those dates in the show notes, and if you go to Trial Lawyers University, to the website, you can see when those dates will be in September. Just putting it out there, Joe, because it's very rare we have to put a case analysis.
Now I'm committed.
No pressure. No pressure.
No worries.
Because that's why I said I did that once, and then the guy's like, "That's why it's called trying a case. You don't know if you're going to win or not. If you knew you were going to win, it wouldn't be that exciting."
That's right. Now I get to do it no matter what the outcome is.
That's right.
Unfortunately, we've talked about this before. You learn probably more when things don't go your way than when they do. At least it hurts more. You remember it more.
Well, you think about it more.
The more you think about it.
You replay it longer in your brain. You never replay the cases you won.
I replay them in my brain. That's
only
true,
the ones you lost.
Yeah.
All right. Well, Joe, a couple things. Obviously, we're going to all be in Vegas at Caesar's Palace, October 16th through 19th. And so, Joe, people need to get a hold of you. I know you're easy to get a hold of, but how do people get a hold of you?
The best way is email Joe at Fried, Fried, Goldberg, GOLDBERG.com. Or my cell phone number is 404-429-6677.
All right. And everybody knows to get a hold of me. It's Dan at triallawyeruniversity.com. And it's 248-808-3130. Let's see. And if you miss anything at TLU, ever miss anything at TLU, it's always on demand. And, I'm really excited, Joe, because, I'm really excited because we're building a AI tool that's going to transcribe and index all of those thousands and thousands of hours of content we've created over the last 3 years. It's going to make it much more searchable. And that's the key part, because people, when you're working on a case, if you go find, 10 examples of that type of case or 5 examples from people that really know what they're doing, it gives you a lot of great ideas right when you need them, because obviously there's so much great information at TLU.
There's no question. TLU's got that, for trucking specifically, it's one of the things that we've tried to do, at the Academy of Truck Acts Attorneys also is, give people the ability to do that. And you're doing it probably at a much more advanced level than we are. But there's something about, you're getting ready to go and depose a corporate representative deposition. And when you can go and find, on demand what, 3 or 4 of the best lawyers in the United States do when they're doing that. How awesome is that? It's like having a personal coach available to you, and you can do it at 3 o'clock in the morning or 3 o'clock in the afternoon. So you do it on your own timetable, which is great. So I love what you've done on the on-demand side, and I think that it's got to be the biggest online repository of trial wealth ever, anywhere.
I think it is, and it's growing every day. And because we're running up to the conference, I got so many live webinars. It's crazy. Some weeks I got 4 of them because basically with all the speakers who are coming, breaking down some of the stuff on some of their cases, so that way, people can kind of get to know the speakers better if that's the person that they want to spend time with, which is one of the reasons I do these podcasts too. So that way the folks that are coming, they can make they're making a big investment of time and money. And it's really important that they get a big return on their investment. And by having stuff more particularized and in smaller groups, I think people get more out of it. So I'm pretty stoked about it all.
Well, I think it's one of the things I appreciate about the way you go about doing this, and I think you know this. I've shared this with a number of your speakers. You have amazing speakers coming. Some of them are historically regional in their reach, or local in their reach, and so people in California or somewhere else may not have heard of them. They're amazing, but they may not be known, right? And so when you have somebody who you don't know, and they're up against somebody like a Claggett or Panish, you might gravitate toward the Panish and the Claggett room. So I think personally, it's really helpful for people to be able to see. Like I know you got Jesse Wilson coming this time, I think for the first time to TLU. He's an amazingly talented guy, but my bet is that a lot of your folks don't know him yet. And so, I think that by you doing some content with him beforehand, let people see what they're in for.
Right, because he's doing some webinars with some lawyers who he's consulted with and helped him with their cases. So that way, people can see what does he bring to the table. Because I have a trial consultant's track, so I got him, I got Sari De Lamont, I got Artemis and David Ball, Eric Oliver, Harry Plotkin, Sonia Chopra, Jessica Brilo, all these great consultants, Philip Miller. And that way people can listen to them, see what they bring to it, and then figure out what's best for them to help them get to the next level. So that's what it's all about.
That's the thing. And I think people should consider when you talk about those amazing people who you just mentioned, I know almost every one of them pretty well. I've learned from almost every one of them. I think that you can think about it as on a case specific thing, like I have this issue in a case. You can also think about it as you, the lawyer, are work in progress. They can help you along that progress. A lot of these people in various ways with different backgrounds can work with different people on everything from body language to eye contact to sequencing to presentation in a way that we just don't get, unless you work with somebody like that. So hopefully, I love doing this stuff. And my hope is that, we're sort of helping bring up a next generation of lawyers who love doing this. And if you love doing it, it's fun. Get outside the box. Go crazy with this stuff, and then bring it back down to to being the best you that you can be, and know that that's going to be an evolutionary process. And Dan, if I can ever help you or anybody who's listening to this or otherwise, I really am a phone call or an email away. If I can make the time, I will do it. It's a commitment that I make publicly, and I mean it. Lots of people will tell you, I really do return phone calls. Not your phone call.
That takes a few days. I fall down there on the priority list. All the people calling you with their cases. It's like, I get it though. Lucky.
I spend a lot of time every week doing that, and I enjoy doing it. I learn from it, and I get from it too. So it feeds my ego. Right?
I agree. It's to me, it's like people, because my friend, she's like, aren't you looking for? You get tired, like, aren't you looking? How long do you think you keep doing this for? all this 2 weeks on the road and all the stuff you got to do every day. I'm like, forever. I can't imagine not doing it. Like, I can't imagine being home for 30 days in a row.
Yeah. Well, I'm with you. To me, this is a lot better than golf. And, thankfully I'm in a place in life where I don't really need anything out of law anymore, for me, but I get so much from it. I hope that makes sense and is taken in the way I intended. I'm not, this is, the way I look at it, I get to do this. I don't have to do this. And I'm so grateful for the opportunity to keep learning, keep doing it. And I'm going to do it as long as I keep getting to do it.
Me too. All right, Joe. Thanks. I'll see you maybe at Big Truck Auto. We'll see. If you're,
Well, either that. If I'm not there, it's because I'm in trial. So
that's right. Well, that's a good reason not to be there.
we'll see.
Thanks.
Thanks.
Ready to train with the Titans and set records with your verdicts? Register for our live conferences and boot camps at triallawyersuniversity.com. Start getting your reps in before the big event by going to tluondemand.com to gain instant access to live lectures, case analysis, and skills training videos from the trial lawyer champions you love and respect, as well as pleadings, transcripts, PowerPoints, and notes for a roadmap to victory. Join the group that continues to get extraordinary results. Trial Lawyers University, produced and powered by LawPods.